that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
Viewers, I've got a good one for you today. Senator John Kennedy once again proves why he's one of the sharpest minds in Washington, a guy who knows how to cut through all the legal mumbo-jumbo and expose exactly what's going on with our courts, our Constitution, and the way our laws are being twisted. This hearing right here? It's a perfect snapshot of why so many Americans don't trust the so-called judicial elites anymore. This is the Prodigy Unfiltered.
Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic that's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that is interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading?
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a
Can you turn your
reconstruction.
microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Now, let's break it down. Kennedy kicks things off by asking these nominees about the rational basis test. That's lawyer speak for the lowest, easiest test courts can use when they're deciding if a law is constitutional. In plain English, it means as long as the government can dream up any reason, even after the fact, then the law stands. And the nominee basically admitted it. Most of the time, the legislature doesn't even tell us what the law is supposed to achieve. Judges just make up a reason later to keep it alive. That right there is a problem. Because in America, laws are supposed to be written clearly, debated openly, and passed with purpose. Not just slapped together and justified later by unelected judges. Kennedy puts them on the spot with a hypothetical. He says, what if Congress passed a law that says if you've got a college degree, you don't have to take a driver's test? Now, you and I both know that's a ridiculous law. A PhD in gender studies doesn't make you a better driver than the guy who works with his hands for a living. But here's the kicker. Under this so-called rational basis test, the nominee admits the court would just imagine some rational reason to uphold it. Maybe they'd say, well, educated people must read road signs better. That's the insanity of it. Judges literally invent reasons to keep bad laws standing. That's not law and order. That's rubber-stamping government overreach. Then Kennedy shifts gears into something really important: how we interpret the Constitution. One of the other nominees earlier said we should interpret it the way Americans understood it when it was written. That's common sense, right? You don't take a contract, twist its words, and pretend it means something else 200 years later. But here's where Kennedy exposes the contradiction. He asks them about Brown versus Board of Education, the landmark case that ended segregation in schools. Now, back when the Constitution was ratified, or even when the 14th Amendment was passed, most Americans didn't believe in racially integrated schools. So, how do you square that with this originalist, textualist interpretation? The nominee basically dodges, saying Brown was correctly decided, but refusing to really explain why. And here's where Kennedy is brilliant. He's showing the tension between theory and reality. Because while I agree Brown was rightly decided, separate but equal is not equal, we can't just twist the Constitution on a whim whenever it suits us. That's dangerous territory. That's how we ended up with Roe versus Wade, Obergefell, and all these activist court decisions that invent rights out of thin air. Now here's my take as a Trump supporter, as a patriot who loves this country. The Constitution is not a living document that changes with the political winds. It's a rock, a foundation, something solid to hold the government accountable. If we let judges dream up rational bases or invent new meanings, we're no longer a nation of laws. We're a nation of judges. And unelected judges shouldn't be running this country. That's the job of we the people through our elected representatives. Senator Kennedy understands that. He's calling out the nonsense. He's saying, stop hiding behind academic jargon, stop dodging tough questions, and be honest about how you'll rule. Because here's the truth, folks. The left knows they can't win on the ballot box with their radical ideas. So they shove them through the courts. That's why Biden is packing the judiciary with activists who will rubber stamp big government and strip away your freedoms under the disguise of precedent or rational basis. That's why Trump's judicial appointments were so important. He put men and women on the bench who respect the Constitution, who understand that their job isn't to legislate from the bench, but to enforce the law as written. And that's exactly the kind of backbone we need to save this republic. So when you watch this hearing, remember what's at stake. It's not just legal theories or classroom hypotheticals. It's about whether the courts serve the people or serve the government. It's about whether America remains a constitutional republic or slides into rule by unelected elites. Kennedy gets it. And more Americans need to wake up and see it too. End of the day, here's the question I'll leave you with. Do you want judges who follow the Constitution as it is written, or judges who make it up as they go along to serve the agenda of the political class? Because that's the fight we're in right now. This is Prodigy Unfiltered. Like, share, subscribe, and stay in the fight. God bless America.